Hi, Gary DeWall here, and this is another Bridging the Week for the week August 19th to 23rd, and today is August 26, 2013. Good morning to everyone. Just like last week, there again were no earth-shattering regulatory developments this week worldwide impacting the financial services industry, but nonetheless, there were some interesting matters around the globe. One thing reverberated in numerous locations, however: algorithmic trading. In the United States, the Financial Regulatory Industry Authority, or FINRA, submitted to the U.S. Securities and Exchange Commission a proposed rule change that identifies what types of trading activity by algorithmic programs within the same organization may constitute wash sales. If this sounds familiar, that's because this proposed rule change incorporates many of the same themes of a proposed market regulation advisory notice submitted by the Chicago Mercantile Exchange to the U.S. Commodity Futures Trading Commission on July 9th. According to the FINRA proposal, all members must have policy and procedures in place that are reasonably designed to review their trading activity for and prevent wash sale transactions. Transactions that originate from unrelated algorithms within the same firm generally will not be considered wash sales, even if they do not result in a change of beneficial ownership, unless, of course, the transactions are undertaken for fraudulent or manipulative purposes. And transactions within the most discrete unit at a member firm, for example, at individual trading desks, will be considered related and thus potentially wash sales. Keep in mind that for FINRA, wash sales are, quote, transactions in a security that involve no change in the beneficial ownership of the security, end of quote. In announcing its proposed rule amendment, FINRA indicated that it is not seeking to eradicate non-purposeful, isolated wash sale transactions. Rather, it is seeking to stop only those firms that engage in, quote, a pattern or practice of effecting wash sale transactions that result in a material percentage of trading volume in a particular security, end of quote. FINRA will announce the effective date of its new rule if the SEC approves it by no later than 60 days following such approval. The CME proposed advisory notice is scheduled to go effective September 9th. By the way, I have a separate article on the CME proposed advisory notice on wash sales on this website. Check it out. On the opposite side of the world, down under in Australia, the Australian Securities and Investments Commission also published guidance on ASIC's market integrity rules for risk management and other requirements. In general, this guidance sets forth obligations of market participants related to risk management for house accounts, supervisory policy and procedures, and minimum requirements of foreign market participants that have come about because of amendments to related ASIC rules that took effect during May 2013. Among other things, this guidance discusses the requirement that market participants trading for their house account set and document appropriate limits, including volume per order limits, aggregate loss limits, aggregate net session limits, and maximum price change limits, and other requirements related to terminal connections. Market participants permitting principal traders to access terminals also have obligations to set and document predetermined limits too. And still on the opposite side of the world, but up north, the China Securities Regulatory Commission announced in a formal press release that it would be conducting a review of the risk controls surrounding the algorithmic trading systems of all brokers in China. This followed the well-publicized malfunctioning algorithmic program of Chinese broker Everbright Securities on August 16th that caused a large swing in the Shanghai Securities Exchange Composite Index on that day. Back in the United States, the CFTC on Friday issued an interpretation regarding retail commodity transactions that was first proposed in December 2011. Under amendments to the Commodity Exchange Act as a result of Dodd-Frank, certain retail commodity transactions are subject to certain provisions of the law. However, generally, transactions that result in actual delivery within 28 days are exempted from these provisions. According to the CFTC's new interpretation, in determining whether actual delivery has occurred within 28 days, the Commission will use a so-called functional approach and consider, quote, how the agreement, contract, or transaction is marketed, managed, and performed, instead of relying solely on language used by the parties and the quote in the relevant written document. Customers may cancel proposed deliveries on occasion under the CFTC interpretation. However, such cancellation must be on limited occasions only, and customers can't enter into a subsequent transaction within 3 business days of a cancellation. And a few small things, but important nonetheless. Do you remember the Foreign Account Tax Compliance Act, or FATCA? I have a hunch you do, but in case you don't, that's the U.S. program to help ensure greater tax compliance among U.S. taxpayers with foreign accounts and assets. Basically, FATCA requires foreign financial intermediaries to enter into an information reporting agreement with the U.S. Internal Revenue Service, or with the IRS's approval, their local revenue authority, or require 30% of payments to such FFIs to be withheld on U.S. source interest, dividends, rents, salaries, or gross proceeds from the sale of U.S. assets. Anyway, without getting into too many complicated details, FFIs were able to provisionally begin registering through the IRS FATCA registration website as of August 19th, although no registration will be considered final until January 1st of next year. All FFIs must register by April 25th, 2014 to avoid penalties, and withholdings must begin July 1st of next year. Now, here's the scariest story of the day. The Public Company Accounting Oversight Board last week issued its second report on the progress of the interim inspection program related to audits of brokers and dealers. For this report, the PCAOB inspected 43 audit firms and reviewed portions of 60 audits of SEC-registered broker-dealers. The result? Deficiencies were found in all the audit firms and 57 out of 60 audits. I think that's an F if I remember high school grading standards. Scarier still, deficiencies in 1/3 of the audits were found in audit procedures related to 1. Capital and customer reserve calculation supporting schedules. This is equivalent to CFTC capital computations and segregation computations. 2. The basis for an exemption claimed by certain broker-dealers to comply with the SEC's customer protection rule. Or 3. The accountant's supplemental report on material inadequacies. Wow, is this scary or what in light of what happened in the last 2 years at MF Global and Peregrine Financial? Many audit firms also failed to satisfy independence requirements. Well, I guess if you're going to fail one thing, you might as well fail this too. The SEC recently approved rules to enhance the audit process around broker-dealers, and the CFTC has similar rules pending regarding the audit of future commission merchants. These PCAOB findings certainly evidence substantial inadequacy regarding the status quo. Last week, FINRA filed and settled an enforcement action involving Morgan Stanley related to the firm's alleged failure at various times from January 2008 through September 2011 to purchase or sell certain corporate, agency, and municipal bonds to customers at prices that were not fair and reasonable, namely, did not reflect so-called best execution. For this, Morgan Stanley paid a fine of US $1 million and paid restitution of US $200,000, almost $200,000. Finally, the end of the fiscal year is approaching soon for many U.S. registrants that will subsequently be required to file, within 60 or 90 days afterwards, their first full annual compliance report certified by their CEO or Chief Compliance Officer. I'll have an article on my website during the first week of September regarding what firms should be doing now before their fiscal year ends to prepare themselves for this report preparation. Check it out. You'll want to avoid those last-minute battles between chief compliance officers and senior management, if you can. Anyway, but for now, that's it for Bridging the Week this week. Until next week, this is Gary DeWaal. Have a great week.